we have a new Director of National Intelligence, and we're going to talk a little bit more about Flynn and this Mandamus thing. So hang with me, folks, and I'll get to it in a minute. Hey everybody, this is Deb with Truthification Chronicles, and we have a new Director of National Intelligence. Woohoo, Ratcliffe! Boy, he's going to tear things up, folks. I really think so. And he was confirmed, I think it was 49 to 44. There were several who didn't vote. I assume they probably weren't there to vote. And they, on both sides, there were some on both sides. Other than that, it went down party lines, I'm pretty sure, if I remember seeing it correctly. So, yes, we do have a new DNI, and that's going to be good news because I'll tell you what, he wants to know the truth. And just in case you may not be convinced of that, remember this? Look at this one. She says, if you're not convinced our new Director of National Intelligence is going to expose every little dirty secret of Obamagate, then you missed this epic takedown of Mueller. Those bottom feeders have no idea what's coming. Okay, folks, here you go. It's about 4.5 minutes long, so hang in there, but it's good.
The report on the bottom of page 2 of volume 2 reads as follows. The evidence we obtained about the President's actions and intent presents difficult issues that prevent us from conclusively determining that no criminal conduct occurred. Accordingly, while this report does not conclude that the President committed a crime, it also does not exonerate him. Now, I read that correctly?
Yes.
All right. Now, your report, and today you said at all times the special counsel team operated under, was guided by, and followed Justice Department policies and principles. So, which DOJ policy or principle sets forth a legal standard that an investigated person is not exonerated if their innocence from criminal conduct is not conclusively determined?
Can you repeat the last part of that question?
Yeah. Which DOJ policy or principle set forth a legal standard that an investigated person is not exonerated if their innocence from criminal conduct is not conclusively determined? Where does that language come from, Director? Where is the DOJ policy that says that? Let me make it easier.
Go ahead.
Can you give me an example other than Donald Trump where the Justice Department determined that an investigated person was not exonerated because their innocence was not conclusively determined?
I cannot, but this is a unique
Okay,
situation.
well, you can't. Time is short. I've got 5 minutes. Let's just leave it at you can't find it because I'll tell you why. It doesn't exist. The special counsel's job, nowhere does it say that you were to conclusively determine Donald Trump's innocence or that the special counsel report should determine whether or not to exonerate him. It's not in any of the documents. It's not in your appointment order. It's not in the special counsel regulations. It's not in the OLC opinions. It's not in the Justice Manual. And it's not in the principles of federal prosecution. Nowhere do those words appear together because respectfully, Director, it was not the special counsel's job to conclusively determine Donald Trump's innocence or to exonerate him. Because the bedrock principle of our justice system is a presumption of innocence. It exists for everyone. Everyone is entitled to it, including sitting presidents. And because there is a presumption of innocence, prosecutors never, ever need to conclusively determine it. Now, Director, the special counsel applied this inverted burden of proof that I can't find and you said doesn't exist anywhere in the department policies, and you used it to write a report. And the very first line of your report, says, and as you read this morning, it authorizes the special counsel to provide the Attorney General with a confidential report explaining the prosecution or declination decisions reached by the special counsel. That's the very first word of your report, right?
That's correct.
Here's the problem, Director. The special counsel didn't do that. On volume 1, you did. On volume 2, with respect to potential obstruction of justice, the special counsel made neither a prosecution decision or a declination decision. You made no decision. You told us this morning and in your report that you made no determination. So respectfully, Director, you didn't follow the special counsel regulations. It clearly says, write a confidential report about decisions reached. Nowhere in here does it say, write a report about decisions that weren't reached. You wrote 180 pages. 180 pages about decisions that weren't reached, about potential crimes that weren't charged or decided. And respectfully, by doing that, you managed to violate every principle and the most sacred of traditions about prosecutors not offering extra prosecutorial analysis about potential crimes that aren't charged. So Americans need to know this as they listen to the Democrats and socialists on the other side of the aisle, as they do dramatic readings from this report, that volume 2 of this report was not authorized under the law to be written. It was written to a legal standard that does not exist at the Justice Department. And it was written in violation of every DOJ principle about extra prosecutorial commentary. I agree with the chairman this morning when he said Donald Trump is not above the law. He's not. But he damn sure shouldn't be below the law, which is where volume 2 of this report puts him.
Oh man, I remember that happening. I cheered him on when I heard that one. He did a great job. And I'll tell you what, that fire is what he's going to bring with him. Now, he's not going to be partisan about things. He's going to be honest about them. He's going to look into things like they should be looked into. And I guarantee he's going to be getting all those dirty secrets out there. We're going to see stuff, folks, because he's been frustrated. He's one of them that wanted to see all these things, and they just never seem to be declassified. Well, I guarantee he's going to declassify stuff that he thinks you and I need to see, and there's going to be a lot of it. So looking forward to that. I'm so excited to see him in this position, although I'm going to miss him in the hearings. He really did a great job in those hearings. So now let's turn to Flynn. I've got to tell you folks, you know that I kind of like reading these legal documents, but I'm not a lawyer and I'm not a paralegal. So some of this stuff kind of goes over the top of my head, and I'm going to give you a little bit of information here, but most of it I'm going to point you to somebody who says it much better than I do. Okay, now I've talked about Undercover Huber before. He does a really good job. This is not the John Huber U.S. attorney, okay? But this guy does a really good job of pointing out a lot of these legal things. And in this, he made some comments. Now, you know that Sidney Powell, who is General Flynn's lawyer, put out this writ of Mandamus, and was talking about, I mean, she laid out several things, but she was talking about how this whole thing about Judge Sullivan asking for these amicus briefs is ridiculous and that he shouldn't be doing that. And, she lays her cases out very nicely. But anyway, so on this, he says, the Court of Appeals has responded to a writ of Mandamus. So he says a few comments about the U.S. Court of Appeals for the D.C. Circuit's order to Judge Sullivan to respond to Powell's writ of Mandamus. And there's, the copy of it. And he says the court didn't respond on its own to Powell's motion. They want to have Sullivan's views on the table, making his own case before deciding on the merits. So this is highly unusual. I mean, so much about this case is so unusual. It's just not what is normally done, which, are you surprised? No, we're not. But with this one, it's really weird. The court ordered the judge to file a response, and usually it's not the judge that does it. So that's going to force Judge Sullivan to put his cards on the table because he hasn't actually denied the DOJ's motion to dismiss. He's just left it sitting there and invited amici to argue against it. That suggests he doesn't agree, but doesn't say it. Now he'll have to say. And they put a time limit on it. Within 10 days is by June 1st, which is way before the oral argument Sullivan scheduled himself in the district court June 10th. Suggests the appeals court wants this decided ASAP. 10 days. Oh. The court specifically invited the DOJ to respond to the writ as well. Barr joining Powell's side and arguing to dismiss the case will make it much more powerful than on its own if he takes that opportunity, which I suspect he will. Yeah, I think he will too. And see, that's where he said the government is invited to respond. The court ignored two of Powell's arguments: to order Sullivan to vacate his order appointing amici and to remove the case from Sullivan, and wants to make it about the core issue, granting or not granting the DOJ's motion to dismiss the case. This makes sense and simplifies it. So in her writ of Mandamus, Sidney Powell actually asked to get rid of Sullivan because he shouldn't have been in charge of this in the first place. But anyway, so that was part of what she said, and she also wanted to overturn his idea of these amici briefs. So those were kind of ignored, and they focused on the heart of the issue, which is really just dismissing the case against Flynn. So he goes on, he says, the court cites two authorities that it wants Sullivan's response to address: Federal Rules of Criminal Procedure 48A, Rules on Dismissal, and U.S. v. Fokker. Both of these were cited by Powell in her writ, and both strongly support her case and that of DOJ's. Now, you're going to hear more about this particular case here in just a minute. Well, actually, if you watch this video that I'm going to show you. Some background on the three judges who will decide the writ here, which these are the three: Henderson, Wilkins, and Rao. Henderson was first nominated by Reagan and voted against Nadler in the House being able to subpoena White House counsel Don McGahn. Rao was nominated by Trump to replace Kavanaugh and also voted against House overreach against Trump. And then Wilkins was an Obama appointee. Senate Republicans' filibuster failed, so he was appointed there. Overall, this is a positive development and will at least force Sullivan to stop playing games and address the core issue of the DOJ's motion to dismiss, which he's been trying to wiggle out of. Doesn't mean Powell will win, that's a high bar, but a good start. Okay? And then he says Powell's view, and he gives this link to Sidney Powell's tweet where she's putting her opinion in. But this is what I really want to show you, because he says, good explainer here by Will Chamberlain. And this video right here, this guy, it's a periscope thing, so you can't like change the speed or anything like you do on the YouTube videos, but it starts just a few minutes in, and he goes through it from much more of a legal perspective. This guy knows a lot more about the law and how things work than I do. So I'm going to leave the link to this so you can make sure you watch this video. It's about 20 minutes long, but he does a really good job of explaining what the whole situation is and how it all fits in. I just think that he does an excellent job with it. And again, he knows more about how the courts work and things than I do, and he does a much better job explaining it than I would. I'll leave the link to this thread, but then I'll also leave a link to this specific post right here so that you can watch that video. And then there's another one, John M. Reeves, who is a founder and member of Reeves Law. And so he has a thread on it as well. His is a little more legalese, so not as easy to understand. But basically he's saying the same kind of things. The wording of the D.C. Circuit's order directing Judge Sullivan to personally respond to Sidney Powell's writ shows it is deeply troubled by Judge Sullivan's actions. So that's a good thing. And then he goes on, he says, the federal rules of appellate procedure govern the filing and disposition of writs in the federal appellate courts. So there are rules that follow what can be done. And especially when it comes to, the situation with Flynn, the DOJ wants the case dropped, but the judge doesn't want it dropped, which is really unusual. Anyway, he says, these are different from the rules Judge Sullivan relied on to justify appointing amicus to oppose the DOJ's motion to dismiss. And then he goes on, Rule 21B1 allows the D.C. Circuit to deny the writ petition outright. That would be Sidney Powell's writ of Mandamus, without asking for a response. They could just tell her to go away and just ignore it totally. This is what happens with the vast majority of writ petitions. If the appellate court instead orders a response under Rule 21B1, it shows it is concerned and wants to hear more about the matter. By obtaining an order for a response, Sidney Powell has already cleared a huge hurdle. If the D.C. court ordered a response and did nothing else, that alone would be a huge deal. But the D.C. Circuit didn't stop there. Rule 21B4 states that the appellate court, quote, may invite or order the trial court judge to address the petition or may invite an amicus curiae to do so. And then it goes on and says, the appellate court is not required to order the trial court judge to address the matter. It has the authority to do so, but doesn't need to exercise it. Even if it wants to hear from the trial judge, the appellate court can simply invite, that is, request or ask, the trial judge to respond. It does not have to order the judge to respond. And even if the appellate court orders the trial court judge, it can avoid requiring the judge to personally defend the action under challenge by appointing a lawyer as amicus curiae to defend the judge's actions. This is what the D.C. Circuit did in the Fokker case, the main case Sidney Powell relies upon in her writ. See the highlighted portion of the fourth image below. And so, yeah, there's all these. In Fokker, the D.C. Circuit said, because both parties seek to overturn the district court's denial of their joint motion to exclude time, we appointed amicus curiae to present arguments defending the district court's action. The D.C. Circuit, in ordering Judge Sullivan to respond to Sidney Powell's writ petition, could have easily appointed a lawyer as amicus to do so. Note that an amicus appointed by the D.C. Circuit to defend Judge Sullivan would have had a job entirely different from John Gleason's job as amicus appointed by Judge Sullivan to oppose the DOJ's motion to dismiss. Had the D.C. Circuit appointed amicus, that lawyer's job would have been to present legal arguments defending Judge Sullivan's refusal to grant the DOJ's dismissal motion, not legal arguments purporting to show why the DOJ's motion should not be granted. But the D.C. Circuit did not appoint a lawyer as amicus to defend Judge Sullivan's actions, unlike in Fokker. Instead, the D.C. Circuit ordered Judge Sullivan to personally respond and defend his actions without an amicus attorney to do it for him. I think this is just kind of funny. This means that Judge Sullivan and presumably his clerks will have to personally submit written briefing trying to legally justify his refusal to dismiss the Flynn case. Yep, he's got some splaining to do. The D.C. Circuit is thus making Judge Sullivan, a lifetime federal judge, publicly and directly explain to them his actions. In short, of all the options available to the D.C. Circuit for ruling on Sidney Powell's writ, the D.C. Circuit chose the most extreme, rare, and drastic of them all. Good for them. It was ordered, not requested, Judge Sullivan to personally, and not through appointed amicus, respond and defend his actions to them. This promises to be anything but dull going forward. So there you go, folks. I thought you'd be interested in seeing those threads. And then just a little bit on Techno Fog here. He says the mandamus will be heard by Judges Henderson, Wilkins, and Rao. Ordered that Judge Sullivan, quote, file a response addressing Flynn's request that this court order the district judge to grant the government's motion to dismiss. Also, the government is invited to respond. So yes, those are the ones. And here's the actual order. You can see it a little bit better on this one, but yeah. That's it right there. And it is an order, so it's not like Sullivan can get out of this. He's going to have to defend his position. And I think this should be pretty fun to watch. What do you think? So that's what I've got for you on this one. I want to thank you for stopping by, and I'll see y'all later.